Hey, folks, welcome to this week's Lawfare Live. It is Friday, March 28th. It is 4 o'clock p.m. Washington, D.C. time. And joining me today is Lawfare Senior Editor Roger Parloff. Hello, Roger.
Hello, thanks for having me.
Mr. Senior Editor Scott R. Anderson. Hello, Scott.
Hello, everybody. Good to see you again.
And Lawfare's newest fellow, who occupies the venerable, esteemed fellowship, which doesn't yet have a name, James Pearce. James, welcome to Lawfare Live.
Thanks, Ben. Great to be here and great to see everyone.
So James is a longtime national security appellate prosecutor. Joins us most recently from the Office of Special Counsel Jack Smith. Before that was had a long career in the appellate section of the criminal division at the Justice Department. And then finally, our special guest, who, gosh, I'm going to have to explain a little bit about how deep my history with David Cole goes on the case that he is here to talk about. David Cole of Georgetown Law School, most long stint as the litigation director of the ACLU, and whom I met when he was a young lawyer and I was an even younger reporter, covering a case of a group of Palestinians yanked off the street and put into deportation proceedings under the same provision that is now at issue. David, it's great to see your face. Welcome to Lawfare Live.
Nice to see you, Ben. Thanks for having me.
All right, we got a world of stuff to cover, so let's jump right into it. And let's start actually with the so-called JGG case, which will set up that conversation. JGG, you will remember, is the Venezuelan case, different provision of law. This is the Alien Enemies Act. But we have a DC Circuit decision. Roger, get us started. What happened in the DC Circuit this week?
Well, and actually, we're also bumping up against the Supreme Court now. But three things happened this week. First, Judge Boasberg down at the district court level actually issued his first lengthy decision, 37 pages. It was a denial of refusal to vacate the TRO that he issued back on March 15th. That's his first lengthy explanation in writing of what he's doing. And actually, he sort of changed his reasoning a little bit. On the same day, there was a DC Circuit argument about staying his TRO, which both blocked the removal of the five semi-named plaintiffs. They filed pseudonymously, so JGG is one of those five. That's his initials. And also, there was a quick class certifications to prevent the government from removing under the Alien Enemies Act any other suspected Tren de Aragua people under the same summary procedures. So that was argued Monday, and we got they actually denied the government the stay, so the TRO stays in effect. That was by a 2-to-1 vote. And I will let James describe that, and then in just a moment. And that has since been, the government is already trying to appeal that to the Supreme Court to get both the TRO dissolved and also to get an administrative stay. immediately. We'll get a response from the plaintiffs on that by Tuesday. And there was some also back at Boasberg's court. What's happening is that the plaintiffs are trying to get 14 more days on that TRO, and they want to expand their factual record before seeking a preliminary injunction. And they obviously want to, I think they have what they believe is evidence that non-Tren de Aragua people were shipped to El Salvador. And they're also, if you remember, there was a third plane. There were two planes that where there was a dispute about Judge Boasberg wanted them to turn around the plane if necessary, and they didn't. And then there was a third plane that left after his written order was issued, and they said, yeah, but none of those people were shipped away based just on the Alien Enemies Act. They all had a final conventional deportation order against them. The ACLU and Democracy Forward want to challenge that. So I think that sets the stage. James, do you want to talk about what the DC Circuit did and I guess what the government is now arguing in the Supreme Court?
Sure. Yeah. Thanks, Roger. And as Roger noted, the week kicked off with the argument, the DC Circuit argument on Monday. And when the government got up to make its case, Judge Millett jumped in and was pretty characteristically questioning a number of aspects of how the government had handled this matter, including why it hadn't sought a stay before the district court, as well as sort of really pushing it on its legal theory. When the government sat down, Judge Walker was then more aggressively questioning the ACLU counsel about kind of the positions that the JGG and the plaintiffs had staked out, and that was and the third judge, Judge Henderson, the senior, the presiding judge, not a senior judge, but the presiding judge, by my count, didn't ask a single question throughout the entire hearing. So I think a lot of court watchers got a bit of a sense of where two of the judges were. But really,
that's just to be clear, though, that's quite typical for Henderson. She's one of the most reticent judges on that court, right?
That is very typical, and in fact was similar to what we saw last week in the NLRB, the National Labor Relations Board, and Merit Systems Protection Board, MSPB argument. She was a bit more active there, but yeah, that's entirely accurate. That she often is a quieter judge from the bench. So as Roger also mentioned, 2 days later, and 2 days ago, as it were, we got 93 pages of opinions from the three judges, ultimately denying the government's motion to stay, to essentially to undo the TRO. And the breakdown was interesting in how they got there. I mean, the first question, in some respects, and this got attention at argument, is whether there was appellate jurisdiction over this appeal from a temporary restraining order. And on that, the three judges split 2-1, with Judge Henderson and Judge Walker both finding that there was, in fact, a jurisdiction, somewhat unusually. So a TRO is typically not subject to appeal. In Judge Henderson's view, there was an exception for what she called irretrievable harm. The government, as I'll mention in a moment, makes some use of this in its stay to the Supreme Court because irreparable harm is also a consideration, and Judge Henderson found irretrievable harm for purposes of finding that there was appellate jurisdiction, but does not appear to find that there was irreparable harm for purposes of the kind of the inquiry, which that I think the government has a fair point in trying to figure out the daylight there. Judge Henderson then on the merits. So I should back up and provide some context, right? one of the core questions was, is habeas the right avenue for relief here? Or is it something else like the actions under the Administrative Procedures Act or the APA? The government's point has throughout essentially been, it's got to be in habeas, and they're in the wrong place. The plaintiffs are filing in DC. They need to be filing in Texas. Judge Henderson sort of seemed to follow what Judge Boasberg had done, which is sort of ask the plaintiffs below, are you still standing by your habeas claim, or are you looking to dismiss it? Plaintiff said, no, we don't need to stand on habeas. We're fine going under the APA, and that's how Judge Boasberg went forward. And that's how I read Judge Henderson to have ruled as well. And that then takes you to the merits of this Alien Enemies Act claim, this claim that you have to, as has already been amply discussed, not today, but in background, of course, the president makes the proclamation that there is, in fact, a state of war or incursions, and that is carried out by the particular Trendo Aragua group. So that's where Judge Henderson takes issue with that there's not an invasion. There doesn't appear to be an incursion, though I don't think she definitively rules on that, and ultimately disagrees that the government can make its showing, that is the likelihood of success on the merits. Judge Millett, by contrast, doesn't think that there is appellate jurisdiction. She doesn't see any exception for the typical rule that a TRO isn't appealable. And in her view, that is sort of amplified by the government's failure to seek a stay in the district court. And she also would not find irreparable harm. And so those are the two that make up the majority. That is the reason that the TRO remains in place. Judge Walker has the view that the government will then, and in fact has today, advocated in its motion before the Supreme Court. He thinks that habeas is the appropriate mechanism, the appropriate way to bring a challenge, that the plaintiffs failed to bring that in the right place. That said, I thought I heard an argument, and Roger, I know you listened. Maybe you either heard or something about this. I thought I heard the plaintiffs say, or the counsel for the plaintiffs say, that they were exploring filing habeas in Texas or taking some action there. That's not reflected in the opinion. That's not reflected in the government's stay application before the Supreme Court. So I don't know whether that's true or not, but nonetheless, that's sort of another kind of curious angle here. Ultimately, Judge Walker says, right, you're in the wrong place on habeas. In terms of irreparable harm, he has a sort of a broader, or I should say, in terms of appellate jurisdiction, he has a broader view that when something is going to significantly sort of imperil or undermine the government's action in a sort of the national security or foreign affairs context, that should be immediately appealable, notwithstanding the sort of procedural niceties. He also is not persuaded by the government's failure to seek a stay below. So you have this 2-to-1 ruling, again, sort of split on questions of appellate jurisdiction and on merits. I think the White House had indicated that they were going to press this to the Supreme Court. It wasn't obvious to me, at least, in reading this, particularly with some of the procedural and jurisdictional hurdles, that was a savvy move, but the government has done that nonetheless. As I mentioned, they very much are kind of tracking what Judge Walker had argued, that the plaintiffs are all in the wrong place, and they as I mentioned a moment ago, they kind of make the irretrievable versus irreparable harm. It's interesting. A lot of that stay application, on my reading of it, and I'd be curious for others who've looked at it, really seems to target Judge Henderson. A couple of times it calls her the deciding vote. I mean, of course, they're all sort of deciding votes in some respects, but they really kind of take her to task for failing to land decisively anywhere. So it'll be interesting to see, as Roger mentioned, the plaintiffs have until Tuesday at 10 a.m. To respond. So we'll see, what they come back and argue. But it could be that these procedural hurdles they give the court a bit of an out, the Supreme Court a bit of an out if they want to take it, because otherwise there's some very knotty and complicated, Knotty, knotty and complicated underlying merits questions here.
And maybe I should just explain, the 5 named plaintiffs are in Texas at the moment. That's why Texas, and there's some law to the effect that a habeas has to be brought where people are confined. And that's that theory. The plaintiff's theory was that they were mainly filing under the Administrative Procedure Act, and the defendants are located in DC, and that was their theory for filing in DC.
All right. Any further thoughts from anybody on JGG before we turn to David Cole and the various long dead immigration authorities that have been revived? All right, let's do that. David, when I first met you in, I want to say 1992, maybe 3, you were counsel to a group of 8 Los Angeles Palestinians who had been rounded up and were slated for deportation under the same provision of the statute that is now being used in the Mahmoud Khalil case. And that case, as I recall, had been going on for 5 or 6 years by the time you and I met, and proceeded to go on for most of our subsequent acquaintance. It finally resolved sometime, it was long after 9/11. So give us the 2-minute history of the LA8, and then tell us about how surprised you were or were not when you heard that Mahmoud Khalil had been, they had attempted effectively a summary deportation of him on the same basis.
Sure. Can I say a word about JGG just before we jump into that?
By all means.
Yeah. I think we are living through, unprecedented times in many respects, but in some respects, a lot of what Trump has done has been done before, but it's been done in real emergencies. In World War II, we interned the Japanese. We summarily executed saboteurs. In World War I, we went after speech, people who spoke out against the war. And in the Palmer raids, we picked up thousands of people using immigration and guilt by association charges, but that was in response to a series of terrorist bombings. After 9/11, we, instituted torture and disappearance and black sites and Guantanamo, but it was in response to a terrorist attack. This time, the only emergency is one of Trump's own creation. And I think that may bode well for the legal challenges. The notion that the Enemy Alien Act is in any way an appropriate measure for this gang that nobody ever heard of until the president declared that they had invaded us, where there's no declared war.
And where there were not just that they had invaded us, but that they are the government of Venezuela.
Yeah. No, it's completely, so I get it that, in those prior periods of emergency, courts didn't do that well. Korematsu being, the principal example, but they didn't do that well. But it's hard for a court to second guess the president in an emergency on what is needed to respond on national security. It's easier when there's no real emergency and everybody knows it. And so I'm hoping that that will be the case. That will be the case here. On the LA8, it wasn't precisely the same. It's a long time ago, Ben. So, it wasn't precisely the same provision. It was the very similar circumstances in which these were mostly college students. They were picked up for advocating pro-Palestinian views in public ways that the government didn't like. But the provision they were actually charged with was, at least initially, was being members of a group that advocates the doctrines of world communism, because they were sort of alleged to be supporters of a PLO faction that is Marxist, that has a Marxist kind of tinge to it, the Popular Front for the Liberation of Palestine. We challenged that ground in federal court as a violation of the First Amendment. And we argued the First Amendment protects speech, irrespective of the speaker, relying on the corporate speech cases that the Supreme Court decided, in which it said exactly that. We said if corporations have speech rights, then surely human beings who are living among us have the same speech rights, and you couldn't punish a citizen for that, so you can't deport a foreign national for that. A Republican-appointed judge agreed with us, struck down the McCarran-Walter Act provision as unconstitutional. The Congress then repealed that provision, passed a new law that made it a deportable offense to provide material support to a terrorist organization. And the government then charged our clients with providing material support to a terrorist organization. And then we litigated that for 21 years. 2008 was when the government finally gave up the case under George Bush. So it started under Reagan, continued under George H.W. Bush, continued under Bill Clinton, and finally George W. Bush dropped the case after we had prevailed in the immigration court. It went all the way to the Supreme Court and many Ninth Circuit appeals in the interim. So
okay, but wait, these guys though are not accused of material support either. They're accused of being hostile to the foreign policy or being annoying to the foreign policy of the United States. Where does this statute come from?
So this is a provision of the McCarran-Walter Act that remains on the books. The provision we got struck down got repealed.
I see. So I got the adjacent provision.
Yes, the adjacent provision.
It's like 30 years, David.
Same law, different provision. This is the provision that gives the Secretary the authority to declare that somebody's presence or activities in the United States poses a serious adverse foreign policy consequence, and by certifying so, deport the person. And he's invoked that with respect to two students at Columbia, a graduate fellow at Georgetown. And it appears he's going to continue to do so. So, but it's in all these cases, it is based on things they said, not material support, things they said that the president doesn't like. And I think there's really two issues in these cases. One is, does the Secretary of State actually have reasonable grounds to claim that a college student's speech on a single college campus actually poses serious foreign policy consequences? I mean, the statute does not say this, the Secretary of State can just deem it. The Secretary of State has to have reasonable grounds. And is that something courts can review? That's I think a serious question. Again, this is a situation where it is obviously not a serious foreign policy problem that Mahmoud Khalil, said, criticized Israel. There's just no. It's a laughable claim. But if the courts say, well, we can't review it, or we have to give substantial deference to the Secretary of State, then the question is, can the government have a power to punish someone who is protected by the First Amendment for clearly First Amendment protected activities that they could not take any action against a U.S. citizen for, simply by giving the Secretary of State this very, very sweeping and broad power? And I think that raises serious First Amendment questions.
Right. So I'm interested in how, first of all, let's just explore for a moment the scope of the principle that you're articulating, because I think it's one that you and I talked about a lot 25 years ago. And, but I think a lot of people have never thought about it. And so if you say to somebody, do lawful permanent residents have First Amendment rights? Most people would say, yeah, of course. But then if you say, can the Secretary of State revoke the visa of somebody because he thinks they're a threat to our foreign policy? You're which a law which has never really been struck down, that kind of says you have First Amendment rights before a court. But if the State Department doesn't like you for some reason, they can revoke your visa, even if your visa is a lawful permanent resident. So I'm curious, first of all, just explain how the doctrine reconciles that, because it seems pretty hard to reconcile. And secondly, um, what do you think when the Supreme Court finally gets this, which I think they will under this litigating posture? Uh, how do you like the chances of Mahmoud Khalil before, under this statute, before this court?
Yeah. So the first question is, do foreign nationals have the same First Amendment rights as citizens? And the Supreme Court has not addressed that question. The lower courts have, including in that case that we litigated many, many years ago, and they have generally said yes. And obviously, in many situations, they clearly do. I mean, imagine that a green card holder burned an American flag. You could not prosecute that person under the Texas flag statute that the Supreme Court held was unconstitutional, because you can't single out flag burning and seek to punish it consistent with the First Amendment. You couldn't prosecute a citizen for that. You couldn't prosecute a foreign national for that. You couldn't impose a single penny sanction on a U.S. citizen for that. Can you deport a foreign national for that, particularly someone who has a green card, permanent residence here? I think the answer should be no, that if the First Amendment protects all people within the United States, and for this speech, you could not punish a citizen in any way, shape, or form. You also cannot punish a foreign national in any way, shape, or form. But this statute was not meant to be kind of a blank check for the government to target speech it didn't like. It was really designed for a situation where you have like the leader of a foreign government or a foreign organization that has taken some actions that undermine our negotiation with some foreign country in ways that really do have serious foreign policy consequences. And you could imagine that in some instances that would be based on speech, but the speech would be sort of, I don't know, evidence. The court is the ultimate ground would be there are serious foreign policy consequences presented by this person's activities. It has almost never been invoked for a person in the United States. One time it was, and a district judge, Judge Marianne Trump Berry, President Trump's sister, declared it unconstitutional under the First Amendment, and then it got mooted out on appeal, so it didn't go up any further. So, I think there's a strong First Amendment argument against it. This is a court that is very good on the First Amendment. No court in our history has been very good on immigrants' rights. So, anytime you're pursuing immigrants' First Amendment rights, it's going to be tough. But again, because this is such a sweeping, a misuse of the authority, I think it's a pretty good case to challenge the propriety of punishing college students for their speech by claiming that it undermines our foreign policy.
All right. So, one additional question just about the environment before we move on. Does it change the calculation at all? And does it change the litigation if the revoked visa is a student visa? Because it seems to me there are a lot more, if you're going after, if you're the administration and you want to get rid of a whole lot of people who were involved in protests related to the Gaza war, a lot of those people aren't lawful permanent residents. They're here on student visas. And how does it change the analysis if you say simply refuse to renew somebody's student visa or revoke them, otherwise leave the facts the same?
Yeah. So I think it's more it feels more outrageous when it's applied to a lawful permanent resident, someone who has been given the right to remain here permanently. But actually the principle is the same. The Supreme Court has said, for example, that the Due Process Clause, which protects persons, protects all persons within the United States, whether citizen or non-citizen, whether here legally or illegally. So even someone who snuck into the country and is illegally present, once they're here, they are a person. They are entitled to due process before you remove them. And the First Amendment doesn't talk about persons. The First Amendment says the Congress shall not abridge the freedom of speech. But because it talks about speech and does not doesn't limit it to the speech of citizens, the Supreme Court has said, therefore, it protects inanimate entities, corporations, because it doesn't matter who the speaker is, we protect the speech. And on that same reasoning, lower courts have held that it protects all immigrants in the United States, including illegal immigrants to the United States. They can be deported for being illegally here, but they can't be punished for their speech. So, and if you're talking about renewing a student visa and the student is out of the country, well, once you're out of the country, a foreign national does not have First Amendment rights. But within the United States, if it's a deportation of someone in the United States, First Amendment applies, whether you're a green card holder or a student visa holder.
All right. We have so far 3 of these cases involving LPRs. I assume we're going to get a bunch involving student visas.
Yeah.
What is the current posture of the litigations involving them?
Yeah, well, it's all very, very early stages. So Khalil's case, Mahmoud Khalil is the Columbia student, the first one arrested, the Columbia student. They immediately took him down to Louisiana to try to get, Fifth Circuit venue, and the New Jersey, but he was in New Jersey when he was picked up, and so the federal court in New Jersey today heard argument on whether he should be brought back to New Jersey and whether he has the right to challenge the government's actions in federal court in New Jersey, including his detention. And heard argument has, took it under advisement. So we don't know what's going to happen there, but he does have a federal affirmative challenge to his detention on this ground, seeking to challenge the constitutionality. Then you also have, I can't remember the first name, but her second name is Chung, another Columbia student who the government has gone after, has sought to put into deportation proceedings, has invoked the same provision. She went into court before she was actually arrested and sought a TRO against them using this in her case, and that is pending in the Southern District of New York. The judge granted a TRO, but basically just let's keep the status quo. I'm not sure I have jurisdiction. I'm going to give the government the opportunity to make jurisdictional arguments. There's another case involving a guy named Mahmoud Khalil who came from Cornell. He challenged his actions, I think, in the Northern District of New York. A court yesterday issued a decision saying that judge found that the federal courts don't have jurisdiction, at least in a case where the government has actually, proceeded with the proceedings. You have to go through the immigration process, which involves an immigration trial and an immigration appeal, and only then can you go to a federal court on a petition for review to a court of appeals, and only then can you really challenge the constitutionality of the provision. And then there's been an affirmative pre-enforcement challenge brought by American Association of University Professors and a number of other organizations that are seeking to challenge the policy of using this tool inappropriately to suppress speech on campus on behalf of lots of people whose speech rights are chilled on campus, and particularly on behalf of people who want to hear the views of the students whose rights have been chilled on campus, and that's at the very early stages. So, you might be right that this will go to the Supreme Court swiftly, but it's also possible that the federal courts say, we're going to let the immigration courts deal with this first, and then that process can take, as I know, can take years before you get to the Court of Appeals. So it's no guarantee that it gets teed up all that quickly. And in the meantime, it is having a extraordinary chilling effect on student protest by immigrants across this country.
Yeah, so one last point on that. One thing that you were able to do for the LA8 relatively quickly, as I recall, is get them paroled.
Yeah.
I think it's possible that the worst possible outcome here for Mahmoud Khalil is you end up stuck in immigration court and they're not willing to parole you or bail you. The guy is not purported to be any kind of a threat. He's not alleged to be anything other than somebody who spoke at Columbia protests. Any plausible short-term possibility for a bail or a parole?
Well, yeah. I mean, that's what they're seeking in the federal court, and they can also seek that in immigration court. The government will obviously, once the government claims you're a threat, they have to act like you're a threat. So they will oppose any form of release in the interim. But a judge has the power to order it, and this seems like a particularly appropriate, instance in which to release them. I will say, if the foreign national is detained, the cases go more quickly. If the foreign national is out, I mean, it was critical in our case that we were able to get our folks out within a month of their initial detention, because because then the time was on our side. Our clients
right.
were here.
The longer they hang out in LA and grow up and get jobs and they have kids, and
Exactly.
all of a sudden they don't look like terrorists anymore.
Exactly. Yeah.
All right. Let us move on. Speaking of the Ninth Circuit, Scott, you have an update for us on the refugee resettlement pause case that everybody's probably forgotten about by now.
It's a very quick update, but since we've been tracking this case a little bit, we thought we would mention it. Folks may recall there's a preliminary injunction from the district court that essentially stopped the halt in the refugee resettlement program. The Ninth Circuit issued a partial stay of that preliminary injunction on the 25th, so I guess that would have been, I think, Tuesday, which essentially said that refugees who had been given conditional refugee status prior to the executive order putting the pause on the refugee admissions would be still allowed in. The stay would remain the preliminary injunction would remain in place for those individuals, but otherwise stay the preliminary injunction. So split the baby a bit there. And that's notable for folks as the preliminary injunction had been seen as a success for restoring the refugee program. Now it's only partially restored for folks who had already gone through the process at the time the block had been put in place. It's now stopped for the others, at least until the final resolution of that issue by the Ninth Circuit.
All right. Let's talk about the expedited removal case, David. This is one of a lot of cases that's going to have Kristi Noem, new prison influencer Kristi Noem, as defendant. What's going on in this case? You didn't even smile at my prison influencer joke.
So expedited removal is is basically summary deportation. It is, and it is, I think, central, assuming they're not able to use the Enemy Aliens Act, which I think is likely they're not going to be able to use the Enemy Aliens Act. Expedited removal is actually critical to the Trump, end goal of radically increasing deportations, because we only have so many immigration judges and we only have so much immigration detention space. And those are practical constraints on how quickly you can increase the numbers on deportation. It just, the judges are really, really backlogged. So, but expedited removal allows the government to essentially short circuit the immigration process through very, very summary proceedings. And it's Congress authorized it to be used for people who have been here for up to 2 years and anywhere in the country. But the executive branch has, by regulation, only used it for people who are caught within 2 weeks of crossing the border, or 100 miles of crossing the border. That's been the policy for a long, long time. Trump sought to expand that the first time around, and we successfully stopped that at the ACLU. They're now again seeking to expand it. If they can expand it, they can, then the fact that there's fewer immigration judges, or not enough immigration judges, is much less of a practical barrier. And there are a number of challenges to the expedited removal. The ACLU has one in DC, but this one is a case brought by IRAP, the International Refugee Association, or something. I can't remember the exact name of it, but it's a claim that they are seeking to apply it to people who have been paroled into the country. Those are people who came to the border, asked for asylum. They didn't have time to adjudicate it right away. And so we parole them in, which means we allow them to come into the country under certain various conditions until such time as their hearing will take place. Those people are not supposed to be subject to expedited removal, but the Trump administration has said that it intends to apply expedited removal to those people. And so that's the principal challenge, that it's not authorized by statute. It's arbitrary and capricious to seek to apply it to those folks. I don't know. I don't think there's been a ruling, but correct me if you guys may know more than I, but that's the issue in the case.
All right. So before we move on from the immigration space, Scott, do we have updates on the birthright citizenship cases? Yeah.
To some extent, more about flagging things coming down the pike. We have 6 different matters that are before the Supreme Court currently. One is JGG, which we talked about earlier. 3 of the others are different birthright citizenship cases that are all being briefed together, or briefed in identical fashion, I should say, by the government. These are all challenges not to the merits of the birthright citizenship holdings in the lower courts, so the government's not conceding that. These are challenges to the use of nationwide injunction by the district courts, and the fact that they've been mostly upheld by appellate courts in the Ninth Circuit, Fourth Circuit, and First Circuit. The different justices, these are emergency motions that have gone through different justices, but just as the government has essentially filed identical briefs in all 3 matters, they've set briefing up for April 4th, not the most expedited time frame, but we just thought worth flagging. We have a big wave of Supreme Court decisions coming next week or the week after, and half of them are these birthright citizenship cases, focusing specifically on the use of nationwide injunction. So we're likely to see some action in that in the week to come.
And Scott, just remind me on nationwide injunctions. Is there any reason why I should be other than cynical about people's views of, like, it seems to me conservatives like nationwide injunctions when they involve Matthew Kacsmaryk, enjoining the FDA from approving mifepristone 20 years ago, and liberals like uh, um, uh, nationwide injunctions when they involve preventing the government from rounding up people who may or may not be here illegally. But there's it doesn't seem like why is the Supreme Court choosing now to be riled up about nationwide injunctions? It's not like this is a new issue.
It's not, and it's not clear that they are getting riled up about it. If anything, it seems quite the opposite. The administration came in with these requests over the last week. I think a few came at the week prior. And they set this briefing date as April 4th to get the response brief sent. That's not exactly an expedited time frame. I don't know if it shows a lot of enthusiasm to take on this particular issue. And they don't have to take on this issue at this phase. Some justices may want to, some may not want to, but they don't, have to decide it. This is a petition for them to exercise jurisdiction. And so there's a good chance, I suspect, that they'd ultimately pass the buck, but they are hearing briefing on it at least.
I would just like to say that all over a certain district court in Texas, people are terrified that that the government is going to prevail on this, and their ability to regulate all of activity all over the United States is going to be destroyed. All right,
Ben, can I just jump in with one comment on the
please.
nationwide or universal injunctions? One thing I didn't mention in the JGG case is that a part of the government's stay application focused on Judge Boasberg's decision to certify a class, and the government calls that essentially a nationwide injunction through the back door. I think later we'll talk about another case up at one of the six that Scott mentioned outside of birthright citizenship and JGG, where the government again is sort of really beating the drum. And so it's as much this administration now, arguably for partisan reasons, that are really trying to tee it up to see if they can find a receptive audience at the court.
All right. I just want to be clear that I, like the Trump administration and most district courts, believe in nationwide injunctions in all cases in which I agree with the injunction. And I find it outrageous that any district judge would seek to impose an order that I disagree with beyond the scope of the four corners of the case before him or her. Let's talk about non-immigrants who the government is going after, which is to say universities and law firms. David, you are joining us from a university. Have you guys been put out of business yet?
We have not been put out of business yet, notwithstanding that our dean was courageous enough to push back very strongly when the U.S. Attorney for the District of Columbia, Ed Martin, wrote us a letter saying that unless we basically cleansed our curricula of DEI policies, he would refuse to hire anyone associated with Georgetown ever again. But the much more serious challenges that folks are facing are obviously the one at Columbia, which Columbia tried to settle. We'll see whether it did the trick, but attempted to settle a week or so ago. $400 million held back for alleged failures to respond sufficiently to anti-Semitism by not cracking down harshly enough on student protests, even though Columbia cracked down more harshly on student protests than probably any other college campus. And the action against Penn, where they have stopped $175 million of federal funding because Penn in 2022 allowed a transgender athlete to swim on the women's swim team, consistent with NCAA rules at the time. It did not cause any cisgender woman to not be able to swim on the swim team. The swim team was open to all, and so allowing a transgender athlete doesn't actually deny participation to any woman because of her sex. And no one has complained about no swimmer complained at the time, no Title IX complaint was filed, and yet 175 million pulled from Penn for this past action that was lawful. And indeed, at the time, and still today, many courts have said that denying a transgender woman the ability to swim on the swim team, that would be a violation of Title IX, because that would be denying her the ability to participate because of her sex assigned at birth. Under Bostock, the case that I argued at the Supreme Court, the court held that that's sex discrimination under Title VII. It would seem to follow, and many courts have said that's also sex discrimination under Title IX. So Penn has not responded yet in a formal way, and so we don't know what Penn will do. But universities have been extraordinarily scared. They are wiping clean any mention of DEI anywhere on their websites, even though that's not required by any law. And just yesterday, there was a letter published by 80 law school deans condemning the Trump administration's targeting of law firms. And that sounds great, right? 80 law school deans are willing to come out and say that what the Trump administration is doing is wrong, until you look at the letter and you notice who didn't sign the letter. And of the top 14 law schools in the country, only 3 deans of those schools signed the letter. Erwin Chemerinsky at Berkeley, the dean at Cornell, and Bill Traynor here at Georgetown. Not Yale, not Harvard, not Penn, not MIT. Well, they don't have a law school. Not University of Chicago, not Stanford. And they, everyone is running scared. So it's a very, I think, very precarious time, and it feels to me like part of the plan here is target places where there might be criticism, there might be opposition, and suppress that opposition. Go after universities, go after students who might come out and protest, and of course, as we've seen now, go after lawyers.
All right. So, Roger, Columbia sought to settle, but there's a lawsuit anyway over what's happening at Columbia. What's up with that? Who's suing, and what is their claim that they have standing over what happens at Columbia that Columbia is not complaining about?
Yeah, I just glanced at this in the at the last minute. This is called American Association of University Professors versus DOJ. I don't have good answers for you on why this isn't moot, or how the standing works. It's that group and the American Federation of Teachers, and it takes issue with the $400 million cancellation, and the cancellation was conditioned on they would lift it if Columbia would punish certain students and abolish certain programs, including the Middle East, South Asian, and African Studies Department, or at least put that under academic receivership. I'm not sure what that means, but I'm afraid it's based on the First Amendment, Administrative Procedure Act, 10th Amendment, Spending Clause. But I'm afraid there hasn't been a TRO request yet. It hasn't gotten very far. I think it was just filed Tuesday. So have
any of you guys looked at this complaint or have thoughts about what this third-party standing theory might be? All right, then we will, if and when anything comes of the case, we will talk about it then. All right, let's talk law firms, because, who knew that the vanguard of human liberty was going to be stand with Perkins Coie, stand with, Wilmer Cutler Pickering. But there we are. So, Roger, we were all despairing that law firms, except Perkins Coie, didn't have the intestinal fortitude to challenge executive orders that targeted them, and they were as spineless and gutless as Columbia University. And then yesterday and today, 2 law firms that we had all been worrying about, WilmerHale, turns out to be represented by conservative super lawyer Paul Clement, who we discussed the other day for his amicus brief in Judge Ho's court. They sued within 24 hours of an executive order targeting them. And of course, losing Jenner and Block, right? Sorry, Jenner people. It's not that I forgot you. I just had an aphasia moment. They're suing as well. So do we now, first of all, what do these complaints look like, Roger? And secondly, do we now, is the world of law firms' supine response a little bit more complicated now that we have the Paul Weisses on one hand, but we also have the Jenners and Wilmers on the other hand.
Yeah, we have 3 that are suing now. And in fact, these, I guess, Wilmer Hale's TRO hearing started about a half hour ago. And Jenner and Block's TRO hearing will start in about an hour. Yeah, 5 firms have been targeted. The first was Covington, and it's a little sui generis because they were only hit with their security clearances were taken away. The next 4 are almost identical. It's a sort of a template. It's an extraordinary template. It's Perkins Coie, Paul Weiss, which, as you mentioned, settled Jenner and Wilmer Hale. And
I just want to say, but just as a matter of legal history, somebody needs to look into this, whether we have ever before had cut and paste executive orders. I think the answer is no, that there's that, like, I've certainly never seen the White House issue like verbatim the same orders about, like, maybe about the State Department does it with terrorist designations, but
Yeah.
like
National
like
emergency declarations are like all identical.
Yeah.
yeah, but like the executive order, come on, guys, you
there's
gotta
a-
get some original language in there. Sorry, Roger.
Well, there's a lot about these that are sui generis, I'm pretty sure. The first section is devoted to defamations of the firm and of 1 or 2 partners, or usually former partners. And they are accused of, no, they aren't accused. They are found to have, committed some wrongdoing that no court has ever found them to have committed, or no ethical
And that
body.
sometimes involves fictitious events.
Yeah,
It's not even that they're not guilty of something. Sometimes the events didn't happen.
yeah, that's true. And then and for example, with Wilmer Hale, the target is Mueller. With Jenner and Block, the main target is Andrew Weissman. By the way, Andrew Weissman, a part of it is he was on the Mueller committee, but they also mention like something he did on the Enron task force. That is 20 frickin' years ago. And so far as we know, he has never been found to have, anyway. And none of these were he wasn't at Jenner then. With Covington, it had to do with, well, that's separate, but pro bono work they did for Jack Smith. Paul Weiss, it was about Mark Pomerantz. Again, and another partner who was on the Mueller investigation. And Perkins, it was
Mark
well,
Elias.
What? Mark
It was
Elias, and also part of it had to do with the hiring of Fusion GPS, that's 11 years ago. And of course, some of these, his grievance about Fusion GPS, he did bring a suit about that, and it was thrown out in about 6 months, and he was fined almost $1 million for frivolousness. So anyway, so there will be first there's the indictment sort of paragraph, indictment and conviction sort of paragraph, and the second one pulls away their security clearances. The third paragraph, it pulls away, it's going to deprive them of federal contracts. But more than that, it requires anyone who gets a federal contract to disclose, do you do any work with this blacklist? Perkins, Paul Weiss, this. And the threat is, and of course, this is confidential information. Are you represented by, do you do? And the expectation is that you'll lose that contract too, even though you didn't even, the client will lose it, even though it's not necessarily through the blacklisted firm. Section 4 has to do with, we're going to go after your DEI programs. And Section 5 is we're going to deprive you of the right to step into a federal building, all of your employees. So federal courthouses, U.S., the PTO, the Copyright Office, SEC, Federal Trade Commission. Perkins works with 90 federal agencies. It also says we're going to ask agency heads to tell all their employees not to engage with anyone in your firm. So it is, there's nothing like it. And now, Perkins did get a TRO. I think significantly, the government, it always pains me to say the government. I can't quite wrap my mind around this is the DOJ, but has not tried to appeal it the way it has maniacally tried to appeal all the Humphreys executor type cases, because they know this is root and branch unconstitutional. But anyway, the TRO issued March 12th, I think. And unfortunately, it's a good TRO, but she read it into the record. So most people haven't read it. And it finds that this template for Perkins violates multiple First Amendment principles. It's discriminatory retaliation. It's viewpoint discrimination. I'm sure David can do this better than me. There's a couple due process claims. There's a Sixth Amendment right to counsel it undermines. She also points out, and I think in all of the complaints, the law firms have pointed out that what this is for all intents and purposes, it's a bill of attainder. A bill of attainder is, however, done by the legislative branch. This is the executive branch. So she's not finding it, but it does everything that a bill of attainder does. And here's what she said. It said, in short, executive order such and such is like a bill of attainder, a punishment for a singled out entity deemed to be disloyal without any formal investigation, trial, or even informal process. This may be amusing in Alice in Wonderland, where the Queen of Hearts yells off with their heads at annoying subjects, and when the Queen of Hearts wants to impose a sentence before a verdict, but this cannot be the reality we are living under. But it is the reality that we are living under. And so these are, that's about where we are at the moment. I think the real problem is that as onerous as these things are, I think the reason that people are settling is that if you are on the blacklist, even if you win a TRO, you're still dealing with the Trump administration, which is fundamentally, not going to play fair. And your corporate department is wondering, well, we need, if we're going to do a merger or acquisition of any size, we need to get DOJ's sign off. Are they really going to do it with us? And the client is wondering, should I really get Perkins? I mean, you can't, they're going to, you're blacklisted. Same with, a criminal case. I'm going to hire you to negotiate with the DOJ. Same with a patent, I'm going to hire. So it's devastating. And I think the ones that are settling, Skadden apparently is settling today. Paul Weiss, I think of it as a litigation powerhouse, but apparently its corporate side is now most of the money. And I think where the corporate side is the money maker, it's sort of too devastating, and they're folding.
All right. We've got about 25 minutes left. I want to get through all the cases, so I'm going to ask you all to keep answers brief. Speaking of Judge Howell, she was asked to recuse in a motion that, frankly, James read like one of the motions to get rid of Judge Chutkin or what's his name in New York. But
Kaplan.
we don't usually see from the Justice Department. Uh, uh, what do we know about Judge Howell's? I mean, she reacted pretty sharply to it. What can you tell us about Judge Howell's willingness to step aside?
She was not willing to step aside, but I want to pause for a moment on the sort of the setup, the way you set that question up, because I think that is as telling here as Judge Howell's actual order was. If everything that Roger said about the attacks on law firms weren't bad enough, I think it's important for everyone to know that to move to recuse a judge requires getting permission from the Solicitor General's office in the Justice Department, and by and large, the Solicitor General's office is extremely parsimonious about that for good reason, right? I mean, the government is about as a repeat player as you can be, and so unless a judge has really done something beyond the pale, and the kinds of examples you might see is, in a criminal case, the area that I know best, where maybe a court of appeals has said you cannot give this defendant this sentence, it is statutorily forbidden, and then a judge does it anyway, perhaps multiple times. That's the kind of case where the Solicitor General's office will sign off. So not only was there sign off here, but as you mentioned, Ben, the actual motion itself was written in about as vituperative and ad hominem a fashion as one might think. And honestly, Roger, you said it pains you to say this is the government. As having been recently in the government myself, it was almost unrecognizable as a government pleading. Now, Judge Howell, I thought, who can be pugnacious, was forthright and very carefully in a 21-page opinion, very compellingly explained that all of these ad hominem reasons, which often had to do, in fact, I think across the board, well, with one exception, had to do with statements she made in court. The one exception was a statement that she made in a speech, explained in context how they were all entirely appropriate and befitting of a judicial role and did not warrant her recusal. I don't believe the government has appealed that. I sure hope it won't. But again, it's just kind of another marker of the state of play in the Justice Department, even separate from what the administration itself is doing.
All right, let's talk federal funding freeze. Big issue in New England for some reason. Scott and James, what we got going on there?
Well, I'll start with one case where we've seen, again, another action at the Supreme Court. This is case number 5 of 6 that we're counting off, waiting with the Supreme Court this week. This is U.S. Department of Education v. California, originally flip it California v. U.S. Department of Education. This relates to a TRO that was given in the District of Massachusetts that directed the reinstatement of various federal education grants that a number of states relied on. It's upheld by the First Circuit, but the government is now seeking to try and get an administrative stay and otherwise reverse from the Supreme Court to stop the TRO from remaining in place. TRO would essentially require the government to keep paying out these funds, and the government raises objections to that, essentially saying that that is inflicting irreparable harm on it. The arguments look, and also I should note that the dispute should be channeled through separate procedures for grant and contract disputes. Those arguments sound familiar. That's because they're very similar to the arguments the government trotted out in the AIDS Vaccine Advocacy Coalition case relating to foreign assistance cutoff. Supreme Court considered about 2-3 weeks ago, where ultimately the Supreme Court denied or declined to intervene and stop a TRO that was compelling additional payments. But this case is arguably, maybe you could see a little ways it's friendlier. It's certainly less egregious in ignoring the TRO issued by the lower court than USAID was in the AVAC case. There's another preliminary injunction that's redundant with it. It causes some confusion. It's a little bit more tailored in its action. My sense is that this is an effort to try and see if they can peel 1 or 2 justices away to join the 4 dissenting justices that would have been willing to invalidate the TRO in the AVAC case. on the slightly friendlier facts. So we'll see what happens with this. Briefing was scheduled due by 4 p.m. today, so it is in theory in the docket now, although I haven't obviously had a chance to read it since we've been online. But we're likely to see action in this case as well coming out of the court next week or the week after. James, I think you have the other case.
I do. The second stop on the New England Funding Free Circuit is a decision that the First Circuit issued on Monday. This is a case styled New York versus Trump. It's actually 22 states that brought challenge on January 28th, I believe, the day after the Office of Management and Budget, OMB, issued a directive that directed a pause in all federal sort of spending and grants that were in service of certain objectives that the directive noted that executive orders sought to prescribe or attack: DEI, the Green New Deal, things like that. The challengers obtained a temporary restraining order. They brought their challenges under the Administrative Procedures Act, again, the APA, essentially saying there was no statutory basis to do this, and it was also arbitrary and capricious in the sense that there was no justification for taking these steps. The district court granted a TRO. The government sought to appeal that. We sort of had a similar discussion with JGG. Ultimately, the government voluntarily dismissed that. The district court ruled and issued a preliminary injunction for the challengers. And the First Circuit, just at the beginning of this week, upheld that, finding that the challengers are likely to succeed on the merits, and that any cutoff in funding would in fact result in irreparable harm. So we'll see where we go next from there, but that is sort of another setback. The government may, as Scott just mentioned, may go to the Supreme Court again or seek to consolidate this, but a preliminary injunction upheld by the First Circuit favoring the challengers to the government's action.
All right, I just want to note that my note sheet here has, for the next two headings, federal firings and agency dismantling. So that gives you an idea of like where we are in the world, that those are whole subheadings. All right, agency firings, we've got probationary employees been dismissed. We've got independent agencies. We've got inspectors general. Go, guys. What how are we doing in firing all the federal government officials?
Well, for probationary employees, it has been a relatively good couple of weeks, but that good run may be coming to an end. We'll see. This is the 6th Supreme Court case. This is a case, Office of Personnel Management v. AFGE. Can't remember exactly what that stands for. It's government employees. It's one of the employee unions for government employees. This case is before Judge Alsup. We've talked about it a fair amount because there's been some dramatic developments in the past few weeks, but the key takeaway is Judge Alsup, while he initially denied a TRO stopping the removal of provisional employees in a number of federal agencies, ultimately reversed himself, saying that he was wrong to have concluded that he lacked jurisdiction to initial the TRO on the basis that his understanding is probationary employees actually cannot go through MSPB proceedings, and issued a preliminary injunction that was appealed, but ultimately upheld by the Ninth Circuit 2-1. The dissenter focusing on this jurisdictional issue, and the government has now moved to the Supreme Court seeking an administrative stay by the U.S. government, while also essentially arguing, look, we need to intervene and quash this preliminary injunction as well, pending the appeal, administrative stay pending the appeal of that. Their basic arguments are essentially that there's no standing in this case. This is a familiar argument where they essentially argue that these various groups involved don't have any direct stake to be able to bring these sorts of claims. They argue no jurisdiction, essentially arguing that Judge Alsup was wrong to have changed his mind. He was right the first time around. These are all just employment disputes that need to go through specialized statutory procedures. This is the Thunder Basin test that we talked about in these discussions in the past that governs that. And then the third argument, which dovetails with something we discussed before, is that essentially this is too broad a remedy. It's similar to the nationwide injunction objections. Essentially, they're saying, look, he's reversing these rules for these huge federal agencies nationwide, although notably it's just a handful of federal agencies, not all covered by this case, as I recall. Regardless, the Supreme Court has scheduled briefing for this next Thursday. So this is the 6th one we can expect a decision on or action on likely in the next week or two. That'll is, of course, one day before the nationwide injunctions cases in the birthright citizenship case, which have that dovetail at the end. We may already be seeing some effect of that in the other case related to probationary employees. This is State of Maryland versus U.S. Department of Agriculture, currently in the Fourth Circuit, where they denied an effort to stay TRO. They've got a hearing scheduled in basically there's an effort to try and stop a TRO in the Fourth Circuit. The Fourth Circuit refused to do that, basically on the logic that the district court was scheduling a hearing to resolve the preliminary injunction measure. And the court held that hearing the 26th, that'd be Wednesday, extended for a number of days the TRO so they could get additional briefing on one additional issue in regards to preliminary injunction, saying that they're inclined to grant a preliminary injunction, but what do they not want to grant? A nationwide preliminary injunction. So they're seeking additional briefing from the parties who are states in this case, where federal employees live or housed, will take public services, or rendered unemployed and have other effects in those states. They've sought additional briefing, seeing what sort of injunction they can issue that is not just a nationwide injunction, but will address all the harms alleged by the plaintiffs in this case. It's an interesting question. I'm interested to see what briefing we get out of it, because it's hard to imagine what sort of injunction you could have that isn't close to nationwide when you're talking about federal agencies in, I think, over 20 states that are a party to this litigation. This is particularly notable, though, because this is actually the litigation in which the nationwide TRO had previously stopped most probationary employees from being fired and had caused them to actually be reinstated, because this applied to nearly every federal agency, whereas the prior case applied to a subset of them. So the resolution of this will be particularly relevant for many, many probationary employees throughout the federal government. Roger, I think you've got the next case here about inspector generals. This is a Storch case.
Okay, the inspector generals we've talked a little about, and James will talk more about. We talked in the past about Dellinger. We talked about Wilcox and Harris. These are variously situated principal officers, and the issue there is whether, the statute says they can't be fired without cause, and the claim is that the Constitution gives the president the right to fire at will without cause. Here, the IGs actually are not, they don't have the benefit of that sort of statute. It says that you don't need cause to fire them, but all you're supposed to do is you're supposed to give Congress 30 days notice before you do fire them. And then you have to give a case specific rationale. It doesn't have to be a good rationale. You just have to go through the motions. And here, and also it's a relatively low level officer, if it's an officer at all. There's an issue. Maybe it's not an officer. Maybe it's just a government employee. Anyway, Judge Reyes held a hearing yesterday, Anna C. Reyes. She seemed likely to grant the TRO. It's actually, I think it's up for a permanent injunction. It's or at least it's either that or a preliminary injunction. But she won't rule quickly.
And James, we have.
Yeah.
Yeah, just an update. Roger alluded to it on the multi-member board cases, the NLRB, National Labor Relations Board, and the MSPB cases. If the outlook seems rosy for the probationary employees and potentially the fired OIG folks that Roger just talked about, it looks decidedly less so for Gwen Wilcox on the National Labor, the NLRB, and Kathy Harris of the MSPB. There was argument that this group discussed last week. The government filed a merits brief today, and then about an hour and a half before we started recording, the same panel that issued 93 pages of opinions in the JGG case bested itself and issued 114 pages of opinions in these cases. The upshot of that is that another 2-to-1 split. Judge Henderson and Judge Walker both would find the government likely to succeed on the merits, and that there would be irreparable harm if the two challengers were kept in their position. And so they are denying a stay pending appeal, moving quickly into the briefing schedule. As I mentioned, the government's already filed its brief. The government's brief, I should add, makes it look likely like, keep chipping away at Humphrey's executor to the point where it probably is disappears. The Supreme Court will have the final word on that. But given time, I think that's probably enough of an update to give people a sense of where those cases lie at this point.
Just one addendum is that I think either this week or last, Trump did fire 2 members of the FTC, which directly presents the Humphreys executor question. I mean, maybe the FTC has evolved since then, but and those 2 have sued in a case called Slaughter. That's just getting underway.
Right.
All right. Let's talk before we have to go. Scott, my friend Mike Abramowitz had the ultimate nightmare, which is like a Trumpy fever dream. You wake up and you find out you've been fired and replaced with Carrie Lake. And so he did what any red-blooded American would do. He sued Carrie Lake. And we have Voice of America litigation since we last talked.
We do. There's a ton of little developments happening all across the foreign assistance and kind of a broader sphere, which I'm just going to try and do a quick whirlwind toward to save as much time as we can. Abramovich v. Lake is the big one about VOA employees contesting their dismissal. All we have really is a complaint in that. That's a legal challenge filed on Wednesday. The government brief is due today, as I recall. We had a little bit more development in another similar case. This is Witakasuwara, v. Lake, in SDNY, in another employee termination case. I don't think for VOA, I think maybe for Agency of Global Media. I can't recall exactly. They had a hearing today in the case where we actually haven't seen it yet, at least as of the last time I checked the docket. But the reporting out of the hearing was that the judge said they were likely to issue a TRO of some sort and was simply drafting the opinion. So that's a good news for that set of employees covered by that decision. We've also seen some interesting developments, 2 other cases related to funding, also related to the unwinding of U.S. Agency for Global Media and related agencies. In one case, we saw Radio Free Europe sue to get their funding back on the basis their funding was being withheld, like a lot of the other funding, foreign assistance cases, other domestic spending cases. But there we actually saw a TRO get granted, and the government almost immediately moved to reinstate their grant the next day, filed a letter saying the grant had been reinstated. We don't 100% know why. And I had initially been under the impression this is only true of Radio Free Europe. We saw the exact same thing happen in another case that another group had filed a lawsuit over Open Technology Funds v. Lake, which is about a kind of an internet freedom nonprofit that had a number of grants or organization. I don't know if it's a nonprofit. They similarly had their grant restored around the same time, which has the effect of mooting the litigation, although it's not clear it was a result of the litigation. So not sure what's happening there, or on the funding side, at least, of the big windup of U.S. Agency for Global Media. In the USAID cases, we essentially are seeing a number of actions, litigation continue in the variety of actions challenging the dismantling of the Inter-American Fund, the African Development Bank, the U.S. Institute for Peace. All of these cases, they've mostly been denied TROs, but they still have arguments, usually on fairly technical grounds, about standing and the ability of the individuals involved, whether or not their harms can be remedied by simply back pay and reinstatement down the line, in which case it's not irreparable harm of the sort that you would get a TRO to reinstate them. But we're still seeing litigation go on in that case. We've seen most of the issues now briefed, at least in Bream v. Morocco. That's the ADB case. There's a hearing on April 2nd in the IAF case. So I think the next week or 2 we'll get a little more clarity about what's happening in those cases. Those cases are also the one where we saw the Justice Department issue a fairly novel, I think it's fair to say, Office Legal Counsel opinion asserting implied constitutional authority on the part of the president to fill vacancies on the boards of those organizations. So that's another legal issue we'll see percolating up to the courts that at least one judge, Judge Leon, specifically called out as somewhat implausible, I think even before the OLC opinion dropped in his denial of the TRO in that case. Finally, in the USAID cases and other foreign assistance cases, we mostly see the payments actually taking place under the AVAC case and the National Endowment for Democracy case. There's continuing to be back and forth and friction around the speed of payments and the reliability of payments. We are also seeing, we know in AVAC, there's a possibility that some of the plaintiffs there may come back to contest the specific cancellation of their grants that was done during the while the TRO was in place, but not being complied with particularly faithfully, at least in my view. In that case, we are waiting to see whether they're going to pursue legal action as part of that matter, an amended complaint, or as separate legal matters contesting those cancellations. I haven't seen any action on that, but there's a deadline, I think, coming up in another week or two that I believe has something to do with that. But I might be wrong. That's off my memory. I don't have that in my notes. The other thing I would note here is also we have now at least the case about USAID employees fully briefed for, there's a motion for summary judgment before Judge Nichols in DDC. He had previously denied a TRO and preliminary injunction, but USAID employees are continuing to contest both the dismantling of USAID and the dismissal of employees. I haven't seen an opinion come down on that, at least I had not as of 2 or 3 hours ago. But we do know, if you're reading the news today, that the Trump administration has announced USAID is being dismantled, folded in the State Department. They notified Congress to that effect about 2 hours ago. And my understanding is that all the remaining employees of USAID have been notified that they are being riffed or subject to a reduction in force, which might cause some friction with some of the issues in this litigation. So I think we're going to see a revival of that case that we haven't heard a lot from in the past few weeks soon. And there is, of course, one last slightly oddball USAID case. That's Doe's 1 through 26 v. Musk, my personal favorite caption of all these cases. James, I think you were tracking this one for us. What's going on there?
Yeah, that's the case.
Wait, I just want to say before James takes this on, this is this week's Who is the Administrator of Doge installment. So James, it's all you.
Yeah, well, I wish there was some clarification or something that would answer this age-old question, but I fear that there's nothing from this particular case. We discussed last week. This is Judge Chuang in Maryland. Challengers, USAID plaintiffs, and personal service contractors arguing that Elon Musk, as the administrator of Doge, was not properly appointed under the Appointments Clause. He was an officer, but not there's no law that congressional law that provided for his appointment, and that the unilateral dismantling of the agency fell afoul of the separation of powers under the Youngstown rubric. Judge Trong had issued a 68-page opinion about half an hour ago, a 68-page opinion granting a preliminary injunction for the challengers. About 30 minutes ago, the Fourth Circuit just stayed that preliminary injunction, issuing about a 45-page opinion. I obviously haven't had a chance to read it, but again, furthering that theme, where the courts of appeals, at least we see this with the DC Circuit and the NLRB and MSPB cases, here we see it with the Fourth Circuit cutting back some of the successes that the challengers are having.
All right. Folks, we have run out of time, and so we're going to defer questions this week. We will, assuming that everything calms down and there are no big actions over the next week, we'll do extra time for questions next week. David Cole, thank you so much for joining us today. And thanks also to my colleagues, Roger Parloff, Scott R. Anderson, and the estimable, venerable Mr. James Pearce. We'll be back next week, and somehow I don't think